My name is David Forsyth, and I'll act this evening as the moderator for the presentation. This event is a collaborative effort of the Waupaca County Bar Association, represented by me, the UW Extension, represented by Professor Mike Colas, and with the assistance of Mr. Robert Cloud of the Waupaca Post. It is our hope that the presentation will provide you a better opportunity to acquaint yourselves with Judge Keith Steckbauer and Assistant District Attorney Vicki Klussman in order to assist you in making your choice between the candidates on the April 1st election. At this time, and before I turn the portion of the program over to Mike Colas to explain the format of the presentation this evening, I'd like all of you to rise and join me in the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, David. Just a few pieces about process and a few rules tonight that I'd like to go through. First of all, we're going to open with a 5-minute opening remark time frame for each candidate. We have a series of questions that have been developed by David, Bob, and I through some voracious research ranging from circuit court judges to Supreme Court justices to law school professors who helped us out in designing those questions. We'll conclude with 3-minute concluding comments at the end of the candidate forum. This is a candidate forum. This is not a debate, so there will not be any interaction between the two candidates. We would ask you to hold your applause until the end of the session. Please do not respond in any manner during the forum to any candidate comments. We have drawn to see who will go first, and candidate Steckbauer has won that draw. He will open with his comments, followed by candidate Klussman. I get that right?
Klussman.
Klussman, thank you. And then the concluding comments will actually start with candidate Steckbauer, followed by candidate Klussman. We have a time limit of 2 hours, so we will get you all out of here by 9 o'clock tonight. Okay?
Can we do this first part standing up?
You can do this first part.
Thank you.
Oh, yeah. One last thing, if you all would turn off your cell phones.
Is this too loud? My name is Keith Steckbauer. I am the current judge in Branch 2. I was appointed by Governor Walker on January 11th, and I took office on January 13th. I took office on February 11th. It was as a result of Judge Hoffman retiring on November 29th with the expectation that there would not be an appointment. However, the governor decided that he wanted to do an appointment. He requested applications. All 4 of us that were in the primary applied. I was selected after several interviews. And I think the reason the governor picked me, which I think is germane to why I think the voters should pick me, is I think I bring things to the table that the other candidates in the primary and ongoing don't. Number one is I think a judge is a general practitioner. In Wisconsin, we have our circuit courts are arranged currently over the last 30 years to be judges of general jurisdiction. That means everything that comes in the door is handled by the judges. By everything in the door, that means from divorces to criminal law to appeal from board decisions, etc. Anything that's a dispute between 2 people or 2 entities or multiple entities comes to judges first in our branches. And as a general practitioner lawyer, which I did for 20 years, I'm most prepared for that. We've all done criminal law. Most of us lawyers here have done some criminal law. I've did plenty. Ms. Klossman's done a lot more than I have. But criminal law is part of what judges do, but I think it's the fact that if there's a real estate issue, if there's an issue with grandma's estate, if there's a dispute between 2 neighbors, if there's a dispute over how the basement was built or not built, I've done those things, and that's why I'm most prepared from a legal perspective. The other reason I think the governor picked me is because of my community involvement. That's not only demonstrated that I'm involved in the community in the sense of I've done everything with my kids that I can imagine, whether it be Boy Scouts, Girl Scouts, flipping burgers at the county fair. I've done all of those things, but I think it's the community involvement that's involved decision-making, which I think brings, is why I'm here today sitting as the judge. And that is that I've been on the board of directors for First State Bank. I've been on the New London Family Medical Center board. I've served as a town board chairman for 4 years. And I've been on the school district for New London for 6 years, retiring 3 weeks ago or whatever when I took the bench. And also 4 years of those as president. All of those things that I've done on those boards has made me ready to make decisions, has had me make decisions, has prepared me to understand how you validate information, how you evaluate evidence, and how you make decisions that are good, bad, but hopefully are the best that you can make on the information presented. I've done that representing children as guardian ad litem. I've made decisions for people, and that's why I think the governor picked me, and I think that's why the voters should pick me to continue in this role. Thank you.
I'd like to start out by thanking the Bar Association and the Extension Office for having this forum and giving us a chance to introduce ourselves to everyone and let you know a little bit about ourselves. My name is Vicki Klessman, and I moved to Waupaca in 1987 when I accepted a job in the Waupaca County District Attorney's Office, and I've been working in that office ever since 1987. I live in Waupaca. I raised my family here. I have 4 children. My oldest is an attorney in Madison. Then I have twins. One is a graduate student at Northwestern University. The other is a teacher in Seattle, Washington. And my youngest is a senior at Waupaca High School. When I started in the district attorney's office, I was assigned to prosecute all of the child abuse cases. I was assigned to all of the sexual assault cases. And at that time, I was also assigned to all of the county's child support and paternity cases. The district attorney's office doesn't handle those cases anymore, but for a number of years, I was doing a lot of family law cases for the county, child support and paternity matters. In addition, in my office, I handle a lot of civil cases. There are a lot of cases that our office handles that are civil in nature, and over the years, I've had a number of civil jury trials as well as lots of court trials in civil cases. But the majority of my practice is in criminal law. And over the last quarter of a century, I've been involved in some of the county's most serious criminal trials, homicides, serious sexual assault, and serious child sexual assault cases. And I've sought and received some of the lengthiest sentences that have been handed down over the last 25 years. In addition to those serious cases that impact victims and families and our entire community, I've also been involved in many other types of cases, property offenses, worthless check matters, traffic matters, batteries, disorderly conducts, everything that our office handles. I feel that as a prosecutor, my job really is to get law enforcement referrals, look at the evidence that's presented, apply the law to the evidence that I'm given, and then to try and seek justice. And I don't think there's another job that really mirrors the role of a judge as much as that of a prosecutor, because we're really looking at the same things. I also would say that prosecutors are in court more than any other types of attorneys, other than maybe public defenders and defense attorneys that do a lot of criminal cases. So over the years, I've been in court in Waupaca County every day for many hours every day in court. I've logged over the last 25 years probably thousands or tens of thousands of hours in court. So I know how the courts run in Waupaca County because I've been here every day assisting victims, assisting merchants and business owners in trying to seek justice, trying to restore them to the the same place that they were before a crime took place. And I've dedicated my life to serving the county, and I hope that you can help me out by voting for me on April 1st. And thank you again for this forum.
Okay, we're in a position now to proceed, and I know that Mike Colas has explained the procedure, and my role will be relegated simply to ask these questions. So the first question is, what personal and professional qualities do you believe are necessary to be an effective circuit court judge?
Well, I think the most important characteristic for a judge, above anything else, is to be fair and try to be impartial and equitable to all the parties. And I feel like in my role as a prosecutor that over the years I've gained the reputation of being someone who tries to be fair to all the parties involved. I've always tried to seek justice for the victims, but also, on the other hand, the people I've prosecuted, I feel like I've always treated with respect and tried to work with them to try and get them to turn their life around and to get the help that they need. So I would say that the most important characteristic for a judge is one of fairness, and I feel that I have that.
I think it's the ability to effectively listen. You know, we're both going to analyze our own experience, and general practitioner lawyers are going to think one way, but I think it's the ability to effectively listen. It's when somebody comes in the door with a novel situation where they don't have a law enforcement putting together a big packet of information for them. It's when somebody comes in the door and says, I have X problem. How do I get out of this? I'm scared. I've been victim of domestic violence. I don't know how I'm going to pay the bills. What am I going to do with my kids? How am I going to get through this? And it's the ability to be empathetic, but I really think it's the ability to listen to find out what people in a role as a lawyer, what they really want. Sometimes it's not what they say, but it's what they're saying, that you need to be able to listen to them. And I think from doing that for 20 years, starting really from whole cloth, from somebody walking the door with their problem, I think that's prepared me to be a judge, because a judge walks in the door often with a very thin file. The prosecutor may have a big one, the defense attorney may have a big file that will know everything about that. But a judge has to almost take it from scratch, listen to what's presented, listen to not just the words that people are saying, but listen to what people are saying in terms of body language, expressions, physicality. It's listening to what people need, what they want, and trying to digest all of that. So I think that's what a judge needs to be able to do, probably above everything else. Yes, I agree we need to be fair, but I think if we're not listening to people, truly listening to people, I don't know if we're going to be in a position to make good decisions for them.
Second question then. An ever-increasing number of cases now involve self-represented litigants, particularly in the family law area. What, if anything, would you do differently when handling cases involving self-represented litigants?
I'm actually really excited about that question, because there's a current proposal by the Supreme Court of Wisconsin to change the rules to allow us to have different orders of testimony. Instead of the formal procedure that we're used to of question, answer, interrogation type stuff, which isn't necessarily a great vehicle to ever get to the truth in a family law matter anyway, goes back to the concept of listening. This rule is going to allow people to do narrative testimony, to allow greater hearsay, to allow just greater informality, and giving the judge, the court, the ability to decide how the information is presented. And so instead of worrying about necessarily asking some unrepresented person who may be scared out of their mind, asking them, are you ready, after the other witness has done testifying, do you have any questions? And anybody that's a lawyer has sat in those hearings, and the person tries to testify, tries to ask a question that isn't a proper question, and they get messed up, and the information doesn't get out. The real questions, the real issues don't get to the judge. So this new proposal, which is pending right now, I'm really excited about, because it's going to give the court the ability to analyze each situation and have a new laundry list in front of them for ways that people can present their information. Because ultimately, at the end of the day, whether it's somebody that's got a professional litigator on their side, or it's just somebody trying their best to explain to the judge their situation, we need to figure out how they can get their information out so they can be heard and a judge can make a good decision for that family.
Well, my experience has been mainly in criminal law, but I know in family law cases, our clerk of court's office does a good job of providing forms to unrepresented individuals to try and help them through that process. But my experience in criminal and civil law, when we have unrepresented individuals in court, I think the courts have to give them a certain amount of leeway, knowing that unrepresented people aren't familiar with the roles of criminal procedure or civil procedure. And so you have to give them a little extra leeway in presenting their case. But I think the courts do a good job of doing that.
Thank you. As a follow-up to the previous question, if the efficiency of the court is being negatively impacted by two pro se litigants, what is the role of the court in trying to increase efficiency? How does your answer change if one of the litigants is represented and the other is not?
Well, again, I think you have to give parties a certain amount of leeway. If you have two unrepresented individuals, I know it's not the court's place to provide them with legal advice, but I think you have to try and help them through that process as much as possible. If you have a case where one party is represented and the other party isn't, again, I think you have to give that unrepresented party a little bit of assistance in helping them through the process without actually providing them with legal advice.
I've been in those situations. When one person is represented and the other one's not, you really have to lean on the attorney and make them essentially, even though they're advocate for one side, they do have to be a bit of an officer of the court, and they do have to do their best, and I think we usually do in that situation, to try to be as understanding as possible. I tried a case this last year where I was the attorney and the other side was unrepresented and did a fabulous job. So I think sometimes it can be done, but it does put a burden on that attorney. But when there's two unrepresented people, while I agree that there's forms, I'll tell you some of those forms are confusing. I've tried to fill them out sometimes, and they're kind of confusing. I think that has helped a great deal in terms of as the model forms have gotten better, that is helping people. But at some point a judge has to, unless there's a significant issue of domestic violence where there's a concern that there's a power and dynamic issue, I think sometimes you have to send the people out in the hallway and say, ultimately you have to abide by the same rules that lawyers do. And that's why I'm excited about these new methodologies that are going to be out there. But I think at some point there has to be some responsibility put back on the people. I say that, though, unless there's an issue with a power and control issue where there's domestic violence, then I think the court certainly has to take a different role, because you cannot ever let or knowingly let that dynamic influence what happens in that family, so that some woman, just to be stereotypical, where some woman may be at risk of making a poor choice because of that power and dynamic issue.
What is your view of the role of alternative dispute resolution in the judicial system?
It works. ADR, alternative dispute resolution for people's benefit, can be anything from an agreement out in the hallway where people work it out themselves, or they hire an attorney to be a mediator who simply helps them work to a solution, or actually hiring somebody to be a decision maker, where you say, okay, we're going to spend some time, we're going to give you information, and you're going to make a decision that's binding upon. Lots of us have agreed to binding arbitration. It's in most of our credit card agreements. If there's ever a dispute with your credit card company, they can force you to do binding arbitration. It works because it's more efficient. The rules of evidence generally don't apply. You have the ability to simply put out your best story and either work to a solution using a mediator or having somebody make a decision for them. It has saved the court system gazillion hours of time, lots of dollars, and I think at the end of the day, it's another way for people to make their own decision. And anytime somebody can make their own decision versus being directed by a judge who's maybe done their best job he or she can do, it's still not as good as a decision that somebody can make for themselves. That's why ADR is effective.
I agree with Attorney Steckbauer that alternate dispute resolution is an effective way of making the courts more efficient. In my experience in the district attorney's office, we don't have, unfortunately, alternative dispute resolution in criminal cases. But I think that mediation is very effective in other types of cases. And in spending a lot of time in court, I've seen that that has been effective in those types of cases. So I think it's a wonderful thing.
How would you describe your judicial philosophy?
Well, I'm not quite sure how I would describe my judicial philosophy. I think what a judge needs to do is take the facts that are presented to them, apply the law to the facts of the case, and make a decision based on that. I don't know how you would term that in terms of a judicial philosophy. I'm a little bit, I guess, of an originalist, but I do know that our laws change and develop over time based on societal changes and things like that. But I think really, especially at a circuit court level, the judge's job is really to take the facts, apply the law, and make a decision based on that.
You know, I hate to use terms that people can read wrong, but I would say that I'm a judicial originalist, conservative, in the sense that we have texts that we have, not given to us on high, but we have texts that matter. They're the statutes, they're the Constitution. Everything that's in the statutes, everything that's done by a judge needs to follow the statutes. Granted, there's a fair amount of discretion in some types of law, but everything a judge does has to be grounded legally and factually in application of a statute, and that statute has to be grounded legally in the Constitution. That's really the end of my discussion in the sense of we have to always have rules. That's what our system is based upon. And if the rules change, then they're really not rules. If we interpret rules to change, they're really not rules. There's lots of ways to change the rules. That's what the legislature is for. The judge's job is to apply, as Ms. Klussman said, the judge's job is to apply the facts to the law as presented. So I guess my judicial philosophy is it's textual, it's strict constructionist, it's looking to what we've been given. We as judges, I as a judge, have been given in terms of statute and the Constitution to make a decision based upon that.
There is a difference in going from the role of an advocate to the role of a judge. How would you assure those appearing in your court that you are not biased as a result of your previous legal experience?
I can answer that. In my month of being a judge, it is different. You know, I've spent, like Ms. Klussman, hundreds and thousands of hours trying cases, a lot of them in this particular courtroom that I'm in. And sitting in that chair, it's different. And I hope to continue with that notion, but it is different. So I guess you have to remember that your role's changed. You're still a player, but your job isn't to second guess the advocates out there. Your job isn't to present the evidence. Your job is to evaluate the evidence given to you. So I think as long as you can find yourself stepping back and evaluating, remembering your role, I think you'll be okay. But everybody I know that's become a judge says that is the hardest thing a judge has to do, is to stop being an advocate. So it's not a trite answer, because everyone tells me, as Judge Hobbit can probably tell back there, it's a real struggle to change that. I'm going to do my best to do it, but it's probably not going to be the easiest thing in the world to do. And somewhere along the line, I'm probably going to forget.
I would say that my role wouldn't really change that much. As a prosecutor, our role is not just to convict people. We aren't really representing the victims in a case. We're representing the state of Wisconsin if we feel that some crime has taken place in the state. So we might get a law enforcement referral where we don't feel that there's enough evidence to prove the case beyond a reasonable doubt. Well, in a case like that, we wouldn't charge the case out. So our role really isn't to advocate for one side or another. It's just to take what we've got, and if we feel the case can be proven beyond a reasonable doubt, then we go forward with it. So I don't see the role of a prosecutor as really an advocate for anyone other than the state of Wisconsin. And so I think if I became a judge, my role wouldn't really change that much.
Waupaca County judges handle a general caseload involving all areas of law: criminal, civil, family, probate, juvenile matters. How would you gain expertise and develop your knowledge in areas of law which you have not have had experience?
Well, I think every attorney specializes in certain areas. And my focus has been in criminal law, but as I mentioned earlier, I also have some experience in civil law and family law. But every attorney has certain areas that they specialize in. And if the attorney becomes a judge, they have to try and read and figure out those areas of law that they're weaker in. And I think the good thing is that if you're learning about the law, you can find that out in a book. Where I think what lawyers need to become a good judge is courtroom experience. And I think I have all of that. The things that I'm weaker on, I can learn that by reading about it. But I have all of the courtroom experience that I think is necessary to be a good judge, and the rest I would learn.
I fortunately, and this is going to sound somewhat presumptuous, but at this point, I've done just about everything. As a small town general practitioner, I've seen or touched, I'm not saying I'm an expert in everything, but I've seen or touched just about every kind of law. And it's not, I did some family law 20 years ago. I was doing family law 8 weeks ago. I was trying cases. I tried a half dozen family law cases, all-day trials last year, more than most years, but I tried a lot of family law cases last year. I've tried cases, adverse possession cases over who gets what outhouse. I got the new one. So I've done all of those things, and I think there's a lot of resources that judges have. A lot of books that have been written are called judicial bench books that are kind of flipped to the index and figure out exactly what to do. But it's been nice while everything is different because you're sitting in a different chair. I have touched all those different kinds of law, and that's what I think uniquely prepares me for this, is that I've been a general practitioner. I have to learn to be a judge, but I don't have to learn the fundamental law at this point in time because of what I've done for the past 20 years.
Civil litigation often requires analysis of motions for summary judgment or declaratory judgment. What is your view of these types of motions, and what approach would you take in deciding them?
Who goes first? Okay. Declaratory judgment, for everybody's benefit, is the concept of something comes in and the judge says, this is the facts presented, this is the law, that simply applies, that there isn't need for, it's basically declaring what somebody's rights are without a trial. Summary judgment is, along the lines of ADR, is the concept where you can figure out how to end a case before it goes all the way through a trial. In other words, the test is, if you look at all the information presented, that everybody gives their best shot forward, best step forward and says, this is what the evidence is there a material issue as to fact? You know, if you look at it, is there really a question? If there's no real question as to the facts, then the court can apply the law and end the case right there. The concept is that you're doing it in writing, you're doing it at maybe a short motion hearing, or it could be a long motion hearing, but you're saving days of trial time. So that's what those things are. My approach is those can be a great time-saving things for the court, and really it's a great economic tool for the parties, because the biggest barrier to litigation and disputes for people is the cost. Lawyers cost a lot of money, $200, $300 an hour. So if you can short-circuit the process for people, it can be a good thing, as long as you're applying the law, you're reading the information carefully, you're giving everybody an opportunity to present their best shot at what the information is, and then applying the facts that there's undisputed or the facts that exist to the law and making a good decision for people. It's just another procedure to save people money and get to the heart of the issue sooner than later.
I agree that summary judgment is sometimes appropriate and can be a way of getting to the heart of the matter and settling a case early. But I think it is important for courts to only do that when they feel it's absolutely appropriate, because I think it gives people the opinion that maybe they didn't have an opportunity to present their evidence, they didn't have that opportunity to be heard in court, and so I think courts have to be careful and do that in limited circumstances only when it's absolutely appropriate.
Okay, family cases, divorce or paternity, often involve allegations of physical or emotional abuse. How would you handle cases when allegations of abuse are made?
Well, I've handled a lot of domestic violence cases over my career, and I realize that that's sometimes an issue in family law cases. And I think you have to be careful to keep separate the issues in family law from the issues in criminal law. But I think the judges have to be aware if there are those allegations of domestic violence that are involved in a family law case, so that you can, take steps to make sure that the victim is protected, both in the criminal realm as well as in the family law case.
There's really been a seismic shift over the 20 years that I've been practicing law in terms of how we deal with domestic violence in the family law setting. Initially, when I first started, there really was no reference to domestic violence. But as we've learned more and more about what the impact of chaos is inside homes, how it developmentally affects children, the more and more we've been learning about that, the more the legislature has given tools to judges, and even actually requirements to judges, to make decisions considering domestic violence. So if you look at all the statutes regarding custody and placement, the first factor that a court has to consider is there domestic violence. Because while it's presumed that for children it's best for them to have a relationship with both parents, and it's presumed that both parents should have a significant and substantial, meaningful relationship with their children, if, however, it's proven, or the court has significant reason to believe that domestic violence is a factor, that presumption of joint legal custody changes. And there no longer is a presumption of joint legal custody if there's domestic violence. So I think a court has to consider that, first by statute, but second, if you don't understand the dynamic of the family as it relates to domestic violence, you won't understand that family and you won't understand those children. So how I'd approach it, of course, is evaluate that issue, and if there's any significant issue regarding the care or custody of those kids, then you appoint a guardian ad litem who's an attorney representative to represent the best interests of those kids to make sure that domestic violence doesn't, or to the extent that you can, minimize it from being passed on to the next generation.
How would you approach a high-profile criminal trial with strong passion and emotion on both sides? For example, the Kinsey case inspired strong passion and emotion against the defendant, whereas a sexual assault typically inspires strong emotions against both the defendant and the victim. How would you take into account the emotional factors when sentencing in such a case?
A judge has to control his or her courtroom. He has to recognize the constitutional rights of the defendant and protect everyone in that setting. And a judge needs to apply the statutory factors that are presented for sentencing: the character of the defendant, the seriousness of the offense, protection of the public. But a judge is also human. A judge is walking into an incredibly charged setting in a sexual assault case where there's horrible wrongs done, in a murder trial where there's irreplaceable wrong done. That's when I think the judge has to do the best job that he or she will ever do in divorcing and separating his or her emotions. It's going to be impossible in the totality to ever be able to do that because we're all human. I mean, it's the greatest system that's ever been developed is our system, but we're still human. So I think a judge has to always take that step back, take a deep breath, and make the decision as devoid of emotion as possible. And I asked Judge Hoffman, who I've succeeded and hope to continue to succeed, what do you do when you're presented with something that frustrates you, that is so emotionally charged that you're making a decision that you know is going to devastate somebody? And he said, take a break, take a recess, take the time necessary to do it right. So that's, I guess, how I'd approach it, is you have to control your courtroom, but you also have to take the time to do it right.
Over the last 25 years, I've had a lot of very emotional sentencing hearings that I've been involved in as a prosecutor. And I think as a judge, I would approach it in much the same way. I would start out by looking at all those factors that you have to evaluate: the gravity of the offense, the characteristics of the defendant, protecting the public, and using those factors to determine what the best sentencing would be. And in cases where you do have high emotions running, I've been involved in situations where victims or victims' families get very emotional and want to act up in court a little bit, or the defendant's family gets very emotional and wants to act up. And you have to do your best to try and work with those people to make them understand that it is a courtroom, that they do have to try and keep their emotions in check, and let them know as a judge that both parties will have a chance to be heard at sentencing. You have to make sure that the victim knows that you're going to listen to their side of it, that you're going to take into account what the victims have gone through, and how the crime has impacted them and their family. And you have to also let the defendant know that he's going to have a right to speak, people on his behalf are going to have a right to speak, but that you won't put up with anyone causing a disturbance in the courtroom. So I think I would be able to do that.
What is your attitude towards special courts or programs created to offer alternatives to incarceration? For example, a mental health court or drug or alcohol treatment court. Are you interested in developing these programs in Waupaca County?
I would be interested in developing specialty courts in Waupaca County. I have been involved a little bit in the Veterans Court that we have in Waupaca County. I think we've only used it a few different times, but I think it's worked really well when we have used it. And it's a court that is designed to help victims with, or help veterans with special needs that they have because of the things that they've gone through. So I think veterans courts are very important. We don't have a drug court in Waupaca County, but I think that that would be a very good thing. We have it in some adjoining counties, and I think it would be important to try and establish that in Waupaca County as well. We do have a SSTOP program in Waupaca, which is for individuals that are charged with operating under the influence, and it's a program to help people become involved in a more intense treatment program, and then their jail sentence is reduced somewhat by the fact that they're involved in treatment. And I think that those specialty courts are very beneficial and helpful, and I would be interested in pursuing more of them like a drug court.
I'm excited about that notion. I'd also like to add truancy court. I've had discussions with district and school districts about the concept of trying to have a truancy court in order to deal with gateway offenses of kids skipping school, especially in that 8th, 9th grade year where we lose boys especially, is to try to have something where we can be a bit of a intermediary, and we can try to nip some of those issues in the bud sooner than later before they go down the wrong road. In terms of the drug court and the veterans court, I think what I'd really like to do is, and I've had some discussions with Outagamie County judges about the concept of doing some of this more regionally. I don't know from a resource perspective or from a volume perspective that Waupaca County needs to have a standalone veterans court, needs to have a standalone teen court, needs to have a standalone drug court. There's got to be ways to utilize the fact that we have surrounding counties that have a greater volume, that have already made a model that is working. And now, I'm not saying that we necessarily want to make somebody drive from Iola to the valley, but there's ways to use the surrounding counties where we can contribute as well, but trying to look at it from a global perspective to take advantage of what's being done in the communities that are larger than us, that have the volume that can really do this and do this well. It is effective. What it is from the drug court and the veterans court perspective is these people have to come in and report every single week, sometimes 2 or 3 times a week, with urinary UAs to see whether they're clean or dirty, whether they've been doing what they're supposed to do. The rules are specific, the court rules are changed so that judges can have ex parte communication, a little more direct contact with the people, so that they can be, it's almost like a social worker type approach, but it's a way to hold people accountable sooner than later. So I think we can do some of those things, but I think we need to look at it globally so that we can try to utilize some of these things that are being done right down the road from us, that are being done with the volume that can make it effective, rather than the risk of let's do something solely for the sake of saying we have one and then not having the volume where we follow through with it, because doing these programs needs to be done and done right. So I think those are the kinds of things that I would like to look at doing.
Specifically, what are your thoughts on teen court?
Sometimes it'd be handy in my house. I have 2 teenagers. So I think teen court really is a way to, teen court can have a whole range of things, from simply having peers making decisions, or having a system where judges have a greater relationship with the kids, so that all of this is about changing behavior before it escalates. And that's really what it's all about, is we have to get these kids that are going down the wrong way because they may have a struggling family or they're falling into the wrong crowd. We need to have methods of interjecting ourselves in their lives and going the right way. So there's 2 different ways to approach a teen court. One method is where teens are peers and they're making decisions, that can only be done if they take it seriously. And it's a little bit of a struggle in our county where you have 12 school districts. You know. So I think there's going to be a struggle with that, but I do believe that there's a way to, there has to be ways done, ways investigated to deal with changing kids' behaviors in that 8th, 9th grade year before they fundamentally change. Because we all know 8th grade kids that raise their hand and are eager and are still excited, and we lose them in 9th grade. That's just statistically correct. So I think whatever we can do to change those paths before they go down the wrong road, I think is imperative for us as a system to do, because it's going to save us a lot of hassle and cost down the road.
We used to have a teen court program in Waupaca County. The teen court coordinator worked out of our office, and I thought it was a very good program. Essentially what happened was when a teen received like a citation or something, instead of paying a forfeiture, they would appear in front of some of their peers who would have a number of different options that they could use to essentially sentence that teen. And it was a way of allowing the teenagers to keep that violation off their record, and it got their peers involved in seeing the types of behaviors that were winding up in teen court. And I thought it was a very effective program, and I would be interested in seeing a program like that come back into our county.
The Wisconsin court system has faced budget cuts in the past few years, and courts have been required to handle increasing caseloads with fewer resources. Do you have any ideas for making the court process more efficient?
That's a good question. I'm not sure how we could make the court system more effective. I think the courts here in Waupaca do a very good job. The judges here do a good job of trying to process cases as quickly as possible. I know sometimes in our office we end up continuing cases maybe more times than we should. So maybe we could work harder to try and resolve cases faster. But it is a problem. I'm sure it's a problem not just in Waupaca County, but across the state in budget cuts and things of that nature. And I really don't have an answer for how we would improve that.
One benefit that I bring to the table, I guess, is I've practiced not just in Waupaca County. I've been in Outagamie, Shawano County, Winnebago County, Calumet County, Portage County a little bit, and several other counties in a smattering. And some counties do things differently. Some counties do things better than we do. Some counties do things nowhere near as well as we do. One thing I particularly like in Outagamie County is, and I really want to do this or investigate trying to do this, is for domestic violence. In the normal domestic violence, often in the middle of a divorce, there's an immediate diversion opportunity offered to the perpetrator. So at their initial appearance, they're screened already, and they're offered counseling, and if they agree to counseling, they're immediately diverted to a deferred prosecution agreement, and in a matter of weeks, they're already in treatment. So in our county, where they may be on their second or third adjourned initial appearance, in Outagamie County, that person is already 6 weeks, 8 weeks into a treatment program to address the problems that got them where they are. And this may be bad, but it actually also reduces attorneys, because this is such a great program for a lot of people, they don't even hire an attorney. So clients come to me and I say, this is what you should do, you should take this, and I don't get paid. So that may be bad for those in the legal community, but it's a great way to divert things sooner than later. So there is ways to do things, and that's just one example, but I think we need to look at what other counties do. I think we do some things very well, but I think that we need to always be sitting down willing to talk to what other counties do. But that's the first thing that pops to my mind is something I really want to do, because it's an extraordinarily effective way to deal with the problem sooner than later and get people on their way to healing sooner than later. Now, that may not work for everybody, but if they're screened out and they're looked at properly, that can be a great resource. So that's one of the ideas that I have that I think we can do things better. Other counties, instead of allowing the district attorney's office and the defense attorney to adjourn things all the time, they require people to be there. And that sometimes having people there get things moving along. So I keep getting the yellow card. So there are things we can do that I do think we need to look at doing.
What have been some recent trends in the judiciary that have impacted the role of a circuit court judge? Do you see these trends as a positive or negative?
No, I'm stumped. No, I think some of the trends are, the positives are the recognizing that the role of the judge can be different than our original model. That's why instead of everything having to be question and answer in the family court system, we're getting this new methodology that allows us to do things narratively, more informally, to get to the heart of the question. Because the system is all about truth. We don't always have to have everything done in this rote formal way. The second thing is in the drug court setting or in the veterans court where they're waiving some of the ex parte rules so the judges can have direct contact with people. All of those things are about looking at different ways to help the judge do what judges really are about, which is our problem solver. Ultimately, our court system is about two people, generally speaking, that disagree about how the world works. And like a parent, a judge has to make a decision for people. So whatever can be done to expedite that, whatever can be done to make it easier for people, and whatever can be done to make the decision right and sooner and better for people gives people a chance to heal sooner. The biggest hurdle for people in the judicial system is not knowing what's going to happen. The sooner you can get people to that point, for the most part, not every case, but for the most part, the better. So those are the trends that I think are positive. Obviously, there's some negative trends as you talk about the impact on costs and volume and those sorts of things. But I think the more tools that we look for, pilots that are done in other places, programs that are being done elsewhere, the more we do that, the more we can work towards getting to solutions for people sooner and more economically.
I guess I would say that the trend that I've seen over the last several years since I started 26 years ago is just an increased caseload in the court system. I've just seen an increase in criminal law cases and every other type of cases. And so I think we have to find ways of dealing with that. And I've seen a trend, a positive trend in trying to find ways to focus more on treatment rather than incarceration. I know in Waupaca we tend to incarcerate many of our individuals, and I think finding alternative ways to deal with people that are involved in the criminal law program and finding ways of expediting cases through the court system is how we would deal with that.
What changes in the judiciary do you see on the horizon, and how do you plan to both impact them and also react to them?
Well, a change I see in the judiciary is that Branch 2 retired. And so we're going to have a change in our judiciary in Waupaca County. I'm sorry, would you repeat the question, Dave?
Certainly.
Thanks.
What changes in the judiciary do you see on the horizon, and how do you plan to impact them and also to react to them?
That's a difficult question. Again, I would say the changes in the judiciary, again, are with case load that the judges have to handle and with being able to expedite cases through the court system, and then dealing with how we treat people that are coming into the court system and finding ways to do that, I guess.
80% of divorces in Milwaukee County don't have lawyers. We're at 50%. We're going to hit 80% sooner than later. So how do we deal, not just in the divorce setting, but in the fact that something like 40% of kids are born out of wedlock? most of us are old enough, we actually know what the term wedlock means. So I think how we deal with the changing family is probably the biggest hurdle that we have. And it's not just in the family law perspective of, yes, I was a divorce lawyer for 20 years, but how we deal with that changing family in the judiciary affects criminal law, which Ms. Klussman is involved in, that I'm involved in now that I'm a judge, and hopefully there isn't a change in the judiciary branch too. But I think how we deal with that changing family is the single biggest goal, is the single biggest struggle that we're going to deal with, is how do we recognize the fact that kids don't have the structure that most of us understand, that voters, most of us understand, is how do we deal with that change? So I think what courts are going to have to deal with is recognizing that their population is significantly different than what we perceive today as the normal population. So that is the struggle that courts are going to face, and I think they're going to have to deal with it with different methods of taking testimony, different methods of relating to people, different ways of utilizing technology to deal with the current technological methods that are used by our customers, which are the people that come into our court. So it's going to be a struggle, but I think courts have to recognize that the family dynamic that affects child in need of protection and that involves child abuse cases, that involves criminal cases, all of that is what's causing our problems.
Some feel that the public has lost trust and confidence in the court system. Do you agree or disagree, and why or why not? What would you do to increase trust and confidence in the judicial system?
In our county, I don't think that there's a sense that we're broken. There are concerns about justice in the sense of how people are charged, when they're charged, who prosecutes, and how fast those cases make it through the system. A judge is going to have limited control over that. Ultimately, that is up to, some of those issues have to be dealt with by the charging authorities. But a judge can hold everyone in his or her courtroom accountable. A judge can require when cases come before them that they move along expeditiously, that adjournments aren't done willy-nilly. Everybody can get one or two, but that there needs to be reasons why cases go longer than they should. Because again, it goes back to the issue of people are okay once they know what's going to happen in their life. So I think there's a lot of good things that we do in our county. I think for the most part, if you ask people on the street, they're going to tell you that the judges do their best and that they trust at the end of the day the right is done. But I will tell you there's frustration in the system with the population about those perceptions. Whether they're real or not doesn't really matter. It's the perceptions, and I think what the court can only do is hold the people that come before him or her accountable.
I've dealt with a lot of victims over the years, and sometimes there is a perception or a lack of trust in the judicial system that they feel. Sometimes it's because there's a delay in the case. There may be a delay in the investigation or in processing the case, or some kind of lack of trust in what the court is ultimately going to decide in a case. And I've always felt that really just trying to communicate to people what's going on in a case helps them to develop more of a trust. If they understand the procedure, if they understand what's going to happen, and if they have some kind of a time frame and know approximately when their case is going to be resolved, there's more of a trust in the system. And I think if we just can communicate to people about what's going to happen and how long it's going to take, that it helps them have a trust in our judicial system.
Please share your opinion on the practice of forfeiting cash bonds towards payment of fine and court costs versus returning the cash to the party that posted the bond.
I think it's a good idea to have individuals forfeit a bond if they don't appear in court, and applying it to fines or forfeitures or costs in the action. Sometimes that's the only opportunity we have to get any money, is when they post a cash bond. So I think it's a good thing to do. I have no problem with them forfeiting cash bonds in those types of cases.
I don't know if our county historically does that. I think that there is a place for it. I just don't believe that historically our county does that a great deal. One of the concerns is bond is the question of bail or bond is what do you impose or require for people to return to court? You know, what do you hold over their head to make sure they come to court? And yes, the tool of forfeiting a cash bond needs to be a tool. Lots and lots of cases in Waupaca County, and really all counties, have a bail jumping charge attached to them because people don't comply. And we don't usually attach the bond to it. And I've only been on the bench for a month, so I don't really have the greatest perspective on that, but I think that's something we need to look at doing. Is you need skin in the game for the people that's posting the bond, for the people that are posting the bond, and for the defendants. It's all about what requirements do you do to make sure they appear in court, and if the cash is the skin in the game to make them appear, then that needs to be on the table.
On a high-volume criminal traffic day, how would you create an atmosphere where litigants feel they've truly been heard by the court?
I haven't had one yet. I've been to them in several counties here. I've also seen it in Winnebago County, and I've also seen it in Outagamie County. And what they do in all the different counties is some counties do what we do, which is it's everybody's there, 100 cases are called. Winnebago County, you can be there for 2 hours for your 5-minute court appearance. And that's frustrating for everyone involved. So every county does it differently. Every county has their own solutions, and every county has their own culture. I guess what I would like to investigate doing is how do you chop that up? How do you break that up so people have a more discrete window that they're going to be in court? And at some point, you as the judge have to stop the presses and make sure everybody understands that they're not just a number. They may be there for a $50 disorderly conduct with a motor vehicle. They squealed their tires. They had a loud muffler. To you and I, that may not seem like a big deal, or it's a 3-point violation. Who cares? They care. So if they care, we have to care. So we have to figure out how do we make sure we recognize that that may be the biggest thing that's happened to that person that month, that week, that year. So how you make sure that they're heard is you hear them and you facilitate the day by making sure you break it down in manageable bites so that they can be heard in an effective fashion.
I have had many, many, many of those high volume criminal and traffic days. And I think usually we do a pretty good job of getting people through. And quite frankly, on a high volume traffic day, there are a lot of people that are there just because they want some time to pay their fine. Maybe they want 60 days to pay their fine, and they really don't want to be heard in court. They just want to get in and get out and go to work. But then some other people might be appearing on their traffic case, and they might want to tell the court their entire life history. And I think it's just important that the courts give individuals an opportunity to speak if that's what they want. And if they just want to plead guilty and get out of there, you get them in and out. But we do a pretty good job of processing on those high traffic days.
In a hotly contested case, attorneys will sometimes get too passionate. How would you maintain judicial decorum?
Well, luckily in Waupaca County, we have really good attorneys that practice here. But over the years, in the district attorney's office, I have had a number of times where I've had to deal with some more aggressive attorneys, some that have a much more aggressive style. And sometimes they come into the courtroom and they want to kind of run the show. And I think our judges here are really good at trying to keep them in line. But if I found that an attorney was trying to disrupt the courtroom in some way, I think the first thing I would do is have them approach the bench and maybe admonish them and tell them to keep in line. And if they continue to be disruptive, I would probably ask them into chambers and tell them there that I wouldn't put up with them being disruptive in the courtroom. I think it's important not to admonish attorneys in front of witnesses and jurors and things like that, but I've had a lot of experience dealing with aggressive attorneys, so I don't think I would have a problem doing that as a judge either.
Well, having once or twice been that aggressive attorney, the best approach in those settings is to have that reputation of you control your courtroom. I think of a judge from another county, Judge Bayarjan. It didn't matter how aggressive you were. You weren't going to push any buttons. And you knew that from the beginning, that there was no guff allowed. And I think if you have that attitude, and I think if you have that mindset that, we're here for business, that we're not going to put up with that stuff doesn't happen. Because I can tell you with Judge Bayarjan, no one ever was an aggressive attorney. I remember a young attorney that was told that if he said something else, he was going to go upstairs for an hour. And I know, I didn't say anything else the rest of that hearing. But it was effective, and as a young attorney. But I think, that a judge like that, and we have judges that way too, and certainly the judge that I've replaced was that way, is you have that mindset of this is his or her courtroom. He will respect you, he or she will respect you if you respect him or her. And if you have that mindset in place, you really don't have a problem with aggressive attorneys. So I think that's how you deal with it.
How would you describe your approach to family law?
Solutions. I will tell you, in 20 years of trying every kind of family case under the sun, that whenever I got to the point where I was trying a case, I had failed. If I got to the point where I could not come up with a solution, using all the ideas that I had and all the case law out there and all the math that could be done, if I got to the point where I couldn't come up with a solution and myself and the other attorney had to go in and have somebody else decide, I had failed my client. Because the point in family law where two people that once loved each other, cared for each other enough that they got married, had a child, multiple children, and now find themselves sitting at opposite tables in a courtroom and having somebody else decide who gets the coffee cups, who gets the bunny rabbit. I've had that. That is an absolute loss for those people because they have given up fundamental control over their lives. So it's unfortunate if you find yourself in that situation. Sometimes, yes, through the best lawyering, you can't get to that point, and sometimes reasonable people disagree, and you have to make a decision, have a judge make a decision. But I've always felt like I failed if I got to that point. So my approach to family law is you need to give people every tool possible, every idea possible, so that they can make choices themselves, whether that be through ADR, whether that be through discussions in chambers, whether it's an in-court pretrial that one judge I know does. Any chance that you can give people an opportunity to go out there and give them plenty of time to make that decision so it's not a rushed decision and that they're making the decision in an informed fashion. But any chance that you can let people make a decision for themselves, you increase the chance that the decision is going to be lived with effectively and that it's going to be a decision that they can respect, abide by, and really take ownership for. So my approach to family law is doing whatever you possibly can to let the litigants make their own solutions.
I've been through a divorce myself, and so I know a little bit about this. I know the devastation that divorce causes to families, emotionally, financially, about every way possible. And I think it's great if you can have individuals sit down and decide things and figure all that out between them, and I think that is always the best approach. But there are times when that just doesn't happen, where parties don't agree on everything. And I think as a judge, you have to be able to try and listen to both parties and try and come up with equitable division of resources and equitable placement arrangements and things like that. I mean, I think solutions are great if parties can decide between themselves how to divide things up, but when they can't, judges have to be ready to make those tough decisions.
How would you describe your approach to juvenile justice?
Well, in our office, we do the juvenile cases, and I think we do a good job of processing juvenile types of cases and finding solutions in juvenile cases. I've had the opportunity to work with a lot of great social workers on juvenile cases. Those cases are particularly difficult, and I think I wish we had a way of making parents more responsible for their own children's behaviors, so that we weren't in the judicial system, and I wish there were some creative solutions to that. But I think our juvenile court system works pretty well in finding ways to try and make juveniles responsible for the actions they've been involved in, and trying to help families through difficult situations through the juvenile court process.
I agree with a lot of that, but I think we can always do better. We need to look at the juvenile justice system, based upon accountability, holding young people accountable for their choices, teaching them through that accountability process what is appropriate, what's inappropriate, but also looking at how can we use this system for diversion. How can we take this person who has an opportunity to change, how can we do that? How can we help them change? They ultimately have to make the decision to change. And I've represented lots of kids going through the juvenile justice system and parents whose children are going through the juvenile justice system. And we have a great second floor, and that's where all the social workers work in our county, who do their best, but I think we need to continue to see how the judiciary can help get them more resources so they can continue to be creative. They can continue to put resources towards diversion, whether that's through significant community service, through effective community service, through counseling, and those sorts of things, school attendance, anything that we can do to give them role models, to give them mentoring, to give them some reason to believe that their world can be different. That, you know, as I talked earlier about the breakdown of the family, a lot of it is because they don't have role models that all of us deserve and expect, and hopefully our children have. So however we can, whatever resources we can bring to bear to help Second Floor do even a better job in diverting and steering kids towards a different way, at the same time holding them accountable, so I as a citizen don't have damage done to my property and my life and simply have it tossed off as, oh, it's just a kid. Well, we have to treat them as accountable for their actions, but we also have to understand that their mind is not fully developed, and what can we do to help them grow, change, and develop when they don't have the family structure that our own children have.
What would you do to garner respect from recalcitrant juveniles?
Oh, Lord. Is this in my own house? I think it's about accountability. It's about using some of the resources that we have in terms of shelter care, immediate, quick responses. I mean, it's almost a little bit like the old in local parentis, where the state steps in and makes a decision for somebody as a parent would. A lot of what we do in the criminal justice system and a lot of what we do with juvenile justice system is trying to act as parents for people that don't have parents, in the sense that I had parents, and hopefully my children have parents, and most of you that are concerned enough to be here were parents and had parents. So how you gain respect with a young child, a teenager in the juvenile justice system, is by holding them accountable, by being respectful to them, letting them know that there are boundaries that they have to respect, and utilizing the tools that you have available to have quick, sure, and serious consequences to them, so they know that their actions are being held accountable, because frankly, that's what they want. They're no different than the teens in my house that sometimes need to be corrected, because that's what they want, is they want structure and guidance. So we in the juvenile justice system have to do what we can to give them structure and guidance. So I guess at the end of the day, a judge has to use the tools available to them to have quick and sure consequences for violation of any rule breaking.
Well, I'm the mother of 4 children, and anyone who's raised 4 children knows that you have to know how to garner respect and how to discipline and watch them grow into adults. And I'm happy to say that my 4 children have grown to be wonderful people. And so you have to know how to garner respect from juveniles in order to get to that point. But in addition, I've been in court many times where we've had juvenile court cases. And so I know that juveniles can sometimes act up in court. And I think if you, in those types of situations, take a firm hand and explain to them exactly what you expect out of them and exactly what type of behavior you expect them to display in court, that you need to do that in order for them to respond to you.
What would you do to improve juvenile case dispositions?
Well, I think we do a pretty good job with juvenile case dispositions. I'm not sure what I would do to change that. I guess I would say that I think it would be important, in addition to just trying to hold juveniles more accountable, trying to hold parents more accountable for the actions of their own children. And so maybe getting parents involved somehow more in the dispositions of cases might improve those.
Wisconsin has 72 counties. And those of us that practice law in multiple counties sometimes would tell you we have 72 states. There's 72 different approaches to things. Waupaca does not have a license on how to do everything right. We need to look at how other counties are doing things and what they're doing effectively. I know of some judges that impose regular reviews where a young person is required to come in and account to them in person, face to face. These are the community service hours that I was required to do. This is what I've done, and this is what I'm doing in terms of school attendance, etc. And some of this is, use some of the technology that we have. In our school district, in order for a kid to play on Friday night, our school can tell you exactly on Wednesday how he's doing class-wise and what he or she needs to do to be able to play on Friday. We can utilize those resources to monitor these kids, and yes, it could be expensive, but we need to be piloting these things and looking at what other people are doing to see how we can hold them accountable, because having a kid come back to you 6 months after he last did what he was supposed to do, and now you're faced with, do you revoke him, do you go back to square one, do you punish him when the incident can be so old? When the failure to comply can be so far back. Anybody that's parented teenagers, and I have wonderful teenagers, knows that you need to deal with things in a quick, sure fashion. So reviews, monitoring, and giving the tools to monitor to the workers that increases their ability to make sure that we're on top of those things. Those are the kinds of things I think we can do to make the system more productive. And I think we really need to look at what's being done elsewhere.
Thank you. This concludes the formal questions part of our program. And at this point, each of our candidates will be given an opportunity to give us closing remarks.
Well, I will do what Ms. Klussman did at the beginning, and I felt bad that, thank you for having us to do this. And I think she was right to thank you at the beginning. Thank you for having this, Mr. Forsythe, Mr. Kellis, and Mr. Cloud, who was writing the questions, wherever he is. Thank you for having us. This has been a roller coaster like no roller coaster I've ever been on. I've been appointed by the governor, moved into Waupaca County. If anybody wants to live in Outagamie County, I have a spare house for them to buy. But I now live in New London. My kids didn't have to change schools. I've had to make a lot of life changes in terms of not being on the school board, bank board, hospital board, and every other thing that I've done. But I'm excited about this opportunity. The past 30 days has whetted my appetite. I hope to continue to be a judge. I like it. I think this is what I was meant to do. I want to do this challenge. I think at the end of the day, if you pick myself or Ms. Klussman, you're going to have a good judge. I just think that the learning curve for me is going to be shorter. I think I'm going to be an effective judge sooner, and I think that I am ready to serve Waupaca County, and I hope to continue to have the opportunity to do that. Thank you.
My opponent has been appointed by Governor Walker, but a judicial race is a nonpartisan race. And it's nonpartisan for a reason. Judges are not supposed to be influenced by political ties or political influences, and I'm not influenced by any political ties. Judges are supposed to be fair and impartial. I've lived here in Waupaca County for 26 years and raised my family here. I've worked here day in and day out in Waupaca County for the last 26 years, and I consider myself a public servant. I've been working for this time to assist the people of this county, the people that I live with and work with every day. Over the years, I've assisted thousands of victims, and I've tried to help people that I've prosecuted turn their lives around and get their lives back on track. So I'm asking now if I've worked, if I've helped you in some way as a victim, or if you know someone who's been a victim of an offense, or if I've been fair and equitable in dealing with you in court, I would ask that you help me out now by supporting me in my candidacy running for judge. So I would ask you to vote on April 1st and to vote for myself. Thank you.
Yes, I just want to take a moment and thank our candidates. First of all, for taking time out of their lives, their day, to be here this evening to share with you experience, information, and knowledge. I'd like to thank the Manawa Masonic Center for making the facility available for this event. I would be remiss if I didn't thank Mike Colas from Extension and certainly Mr. Robert Cloud for the input and recognize their input in putting together this program. And more importantly, I'd like to thank you on behalf of everyone here for coming tonight. If this program has been of some benefit to you, we're all grateful. And please share with anyone who may not have been able to be here this evening that our friends from Waupaca, New London, and Manawa have recorded the program to be replayed in the respective communities. And so there will be an opportunity for others to hear from the candidates in the same fashion that you have this evening. So thank you all for coming. If you want to spend some time here after the presentation to meet with one or the other, the facility is open, and I'm sure that neither one of them would, it would bother neither one of them. So with that, thank you all for coming.
Thank you, Dave. Yep, thanks, Keith.
Hey, Tom Johnson, I'm doing this for you. This matter is
Thank
adjourned.
you, Mike.